Dispute resolution centers versus arbitration law firms. Which one is better for commercial disputes? Most businesses assume that arbitration always requires a law firm. The surprising truth is that dispute resolution centers offer unique advantages that can complement or even outperform traditional arbitration law firms in certain commercial disputes. Arbitration law firms bring legal expertise, case strategy, and advocacy to the table. They draft submissions, represent clients, and argue complex points of law. This is essential for high-stakes disputes involving significant sums or legal complexity. For instance, a construction contract dispute worth millions typically needs experienced counsel to protect the client's interests and manage procedural challenges. Dispute resolution centers, however, provide institutional support for arbitration and mediation. They offer pre-selected panels of neutral arbitrators, standardized rules, administrative assistance, and often lower costs than a full law firm approach. For example, an international supply chain dispute can be efficiently managed through a dispute resolution center, where timelines are controlled and neutral oversight helps parties reach resolution faster. The key difference is structure versus advocacy. Arbitration law firms provide deep legal representation, while dispute resolution centers provide process efficiency, neutrality, and administrative support. Many successful cases combine both. Firms handle legal strategy and advocacy, while centers provide a structured, enforceable platform for hearings and settlements. The takeaway is clear: choosing the right approach depends on the dispute's complexity and your priorities. For fast, structured resolution, dispute resolution centers are invaluable. For high-stakes legal strategy, law firms are indispensable. The surprising truth is that combining both often delivers the best outcome: speed, cost efficiency, and legal protection in one.